6 to give me 4.
Okay, take your time.
I wish I had some more notice.
That's right.
Thank you. All set?
I'm going to have to give him my computer.
No problem. Take your time. This is case number 681270. We are on the record in the state of Ohio versus Akram, who is here today for sentencing with his counsel, Greg Roby. The state of Ohio is present represented by prosecuting attorney Joe Lucchese. On a previous date, Mr. Akram entered a change of plea, originally charged with aggravated vehicular assault, a felony of the 3rd degree, aggravated vehicular assault, a felony of the 4th degree, driving while under the influence, a misdemeanor 1 in the counts 3 and 4. A change of plea was entered in count 2 to the felony 4 of aggravated vehicular assault, an offense that carries a possible prison term of 6 to 18 months in monthly increments, a fine of up to $5,000, a class 3 license suspension, which is a 2 to 10 year period. The DUI carries up to 6 months in jail. As all DUIs, it does carry mandatory time, 3 days, up to 6 months, and a fine up to $1,075. We passed for sentencing, and since that time, I did receive a sentencing memorandum from each of the parties here, which I've reviewed, and I'm prepared to proceed. Is there any reason not to proceed at this time?
We're prepared to go forward. Thank you.
Thank you. We're going to hear from the state of Ohio. I understand that
Thank you, Your Honor.
the named victim, Mr. Cole, will be addressing the court, possibly his wife. Then we'll hear from Mr. Roby, and if you'd like to say anything, Mr. Akram, you may. Thank you. Mr. Lucchese.
Thank you, Judge. Before I get started here, I just want the court to be aware that I have the victim present. Mr. Cole is in the back of the courtroom with his wife. he will wish to speak after I give my little spiel here. So, first of all, we're here because officers arrived to the scene of a motor vehicle accident. They saw the victim lying unconscious and unrecognizable. This motor vehicle accident was between a motorcycle and a small SUV, and they saw the motorcycle 15 to 25 feet in front of the victim who was lying unconscious in the roadway. And an investigation determined that the victim was sitting at a red light on his motorcycle when the defendant came through that red light and plowed through the victim in the process. The defendant and the victim were in the same direction of travel, so the defendant hit the victim from behind, and he essentially did not see any of this coming. I will show the court a little snippet of the scene in a moment, but I wanted the court to be aware that the vehicle crash data in this incident shows that the defendant was driving 39.8 miles per hour 5 seconds before the crash. At the time of impact, 0 seconds to impact, he was driving 45.6 miles per hour. And the victim was catapulted over 3 lanes of travel, and he was in the on-ramp to I-40. So I will show the court a little video of that, a visual of that. What we're looking at here is dash camera footage from Officer Knuckles with Oakwood Village Police. He's the second police officer to respond on the scene. And he is driving down Fair Oaks Road, and he's going towards the intersection of Fair Oaks and Forbes Roads. I'm going to pause it right here real briefly. It's hard to tell, but over on the left side of the screen, we have the headlights from the defendant's vehicle. Those are up against the guardrail over here. The officer was traveling on the same direction that the victim and the defendant had been traveling prior to the accident. Based on the fluids and whatnot in the roadway, we believe that the victim was in the right-hand lane in the left tire track section, since he was on his motorcycle in the right-hand lane, and then the impact occurred. If we notice, we drove all the way through the intersection, and the victim is even further beyond that intersection. And then way back here, there's a lump of metal. That's his motorcycle. Furthermore, the vehicle crash data shows 0 braking prior to impact. And it shows that the steering wheel was moved within 4 degrees of center, not any further. Essentially, that's just driving down the road, keeping your car in its lane. As a result of this incident, the victim sustained numerous injuries, including a skull fracture, paralysis, and broken bones. The victim prior to this incident was a firefighter with Oakwood Village and Cleveland Fire, and EMS arrived on scene, and they did not even recognize him at first due to his injuries. And for the record, Oakwood Village was the responding department to this incident. Ultimately, with regards to sentencing in this case, since this is greater than the normal, this is more extreme than the normal for an aggravated vehicular assault. The state is asking for 18 months on count 2, and then we are asking for 180 days on the driving while under the influence. As noted in our sentencing memorandum, this court can impose consecutive sentences on the misdemeanor and the felony 4 due to the fact that these are not allied offenses of similar import. The last thing of note is that in crafting this plea offer, my office has provided a significant amount of mitigation for this court to consider in its sentencing by reducing the overall charge from a felony 3 to a felony 4, thereby reducing his total exposure for prison time by over half. Because if you note on the indictment, he was facing 60 months. Now he's facing a maximum of 18. So we would ask that the 18 be imposed in addition to the 180 days. If there's nothing else from me, I would ask the court to allow the victim to come forward and speak, and potentially his wife as well.
Sure. Thank you. Sir. Good afternoon. I'm Joan Synenberg. I'm sorry to meet you under these circumstances. You're Mr. Cole?
Yes, ma'am.
Gotti Cole?
Yes, ma'am.
Thank you. Good afternoon.
Good afternoon.
You have a right to be here and to say how you've been impacted by this
Ma'am.
offense. Thank you. This would be Mrs. Cole?
Yes.
Thank you. Sorry to meet you under these circumstances. May I ask you your first name, please?
Patrilla.
Thank you, Ms. Cole. Sir.
This incident has affected me and disfigured me physically, emotionally, and physically, as well as my family and my friends. When the defendant assaulted me that evening, it has changed me permanently. But I'll never think I may ever be able to rebound from it. And that the assault has changed everything. My days are filled with pain and sadness every day. I haven't had a good night's sleep since the assault of that evening, which I was riding in the community in which I served and that I frequent and where I felt safe. And now that's changed the whole perspective of everything in my life. There's no more happiness. The things that I've enjoyed, I can't enjoy anymore. The defendant, after this proceeding, will be able to get up and walk out, and I won't. The things that we take for granted, just to get out of bed, walk, go to work. The defendant can still go to work, and I can't. The job that I've been at for 23 years, serving the city of Cleveland with pride and joy, I can no longer do again. I'll never be able to get on a fire truck again, which has been over half of my life. And that pain, I really can't put in comprehensible words. And the effect on my family, my children, where you can't take your kids to school anymore. You can't tuck them into bed anymore. The things that you enjoyed your whole life. And the parent that they seen you as your whole life is gone. Everything has changed. And I may never be able to get it back the other way. The defendant sitting next to me is truly a predator. And truly a complete a person that you just cannot describe into words what he has done to me. And any community or any surrounding community that he frequents, lives, or exists, he truly should be considered a predator, because anybody that he could come in contact with, this could happen to them too. I have no doubt, after he serves whatever punishment that is doled out to him today, that he will do this again. And I pray that no other family is victimized like this, because I can't put into words how one day you're just a completely happy, functioning, productive citizen in the cities that you served and that you lived. And now I'm just a shell of the man that I used to be. And that I cannot forgive. And that is something that I'll never forget. Thank you.
Thank you for your very powerful words today. I'm very sorry to hear how you're doing. I heard you. Your voice is strong. I appreciate your time today. My very best wishes to you and your family. Thank you. Ms. Cole, did you wish to say something?
I do. You, sir, which is the only name I can call you while in this courtroom, and be respectful to the judge and others here today, as you do not deserve to be called by the name you go by or the name your mother has given you. That name has a definition that you are not. Sir, your actions of drinking and driving has not only affected Gotti Cole, but it has affected many, his daughter, his mothers, a host of family and friends, and myself. You, sir, will never be forgiven for your actions and what it has caused. Individuals like you who drink and drive never learn. You won't learn your actions. You won't learn how your actions affect others until you kill yourself or you kill someone else. If that happens, you will then have the ability to go to a jail cell and hopefully live out the rest of your life. Today, sir, you have the ability to walk out this courtroom, to hopefully serve the jail time you are to serve, or back home to wait until they tell you you must report to jail to serve your time. Sir, Gotti Cole is being told he will not be able to walk again, and that is due to your actions. Again, you will never be forgiven. You not only changed the life of Gotti Cole, you have changed the life of many with your actions. Sir, you will never be forgiven for your actions of drinking and driving and hitting Gotti Cole on May 12, 2023, while he was currently stopped at the light, and you, sir, were under the influence and cannot control yourself. Again, I want you to know you will not be forgiven by anyone in this court, his family, or his friends. Thank you.
Thank you, Mr. and Mrs. Cole. Appreciate it. So sorry for what you're experiencing. Thank you.
Judge, one last thing. Defense counsel and I stipulated to the matter of restitution. The victim's out-of-pocket expenses with regards to this incident are $19,783.63. So we would ask that that be ordered as well.
Based on the stipulation of the parties, restitution is ordered in the amount of $19,783.63.
Thank you.
Thank you. If there's anything further on the state as we proceed, please let me know.
I'll be happy to state, Your Honor.
Thank you, and thank you to Mr. and Mrs. Cole. Mr. Roby?
Thanks very much. So, Your Honor, I would begin remarks by saying that both myself and Mr. Akram extend our deep condolences.
Stand up, sir. Thank you.
And our apology to Mr. Cole and his family for the serious injuries that he suffered. That being said, I would echo some of the comments that I made within my sentencing memorandum. Ali is before you. He's 52 years old. He's engaged to be married in a stable relationship with his significant other. He has 3 grown children, He lives in North Randall, has a stable home. He does factory work. He works at Lubricant Solutions in Macedonia, and it's a stable job. As far as his record, he has a very old record. I think we shared that with the court previously. It goes back over 20 years to a drug case. So he does have a record, but it's very remote in time. I think the salient point, if we examine his record, is he does not have any history of OVI offenses, DUI offenses, or alcohol-related offenses. The facts of this case, I don't think are in great dispute here. That Ali was drinking at the casino. He made the terrible decision to jump on his motorcycle and try to drive home. It was late at night, it was dark, he did not see Mr. Cole, and he smashed into the rear of his motorcycle. And there's no dispute that Mr. Cole, as we've seen here today, suffered life-changing injuries. And there's nothing that I'm going to say or Mr. Akram is going to say that's going to change that. I do think it's worthy of mention that in my review of these videos, and we can actually see by looking at this video screen here, that Mr. Akram was on scene, standing over Mr. Cole, hoping to try to render some type of aid before EMS got there. He didn't attempt to run from the scene or anything like that. I think there are a number of factors that I would ask the court to consider here. First, never in a million years did Ali contemplate that he would cause such devastating injuries. Second, I think it's apparent that he's accepted responsibility without issue. Never tried to blame anybody else but himself. He's the person who jumped in his car after drinking and caused the accident. Third, if we look at his letter, and I think you're going to hear a statement from Ali today, there's genuine remorse. He wishes this never happened. He understands that there's going to be consequences here. He's prepared to accept those consequences. Those are the things that I would ask the court to consider. Thank you.
Thank you. First of all, I'll note that it was mentioned that there was a plea agreement here. The court doesn't participate in plea negotiations. That's between the parties. So what you pled to is what I'm sentencing you on, sir, without consideration about what you were originally charged with. What would you like to say on your own behalf?
Yes. On May 12th, first of all, I'd like to apologize to Mr. Cole and his family. That night, I heard the prosecutor say he was on the right lane. I was on the right lane. It was cars in front of me. I was wondering why no car was on the left. I jumped to the left. The time I jumped to the left, I hit him. Soon as I hit him, I jumped out of the car. I was on my knees. I was rubbing his back. When I moved it and saw his face, that's when I just broke out, cried. I ain't cried since my mother and father died. And I prayed, and I ain't prayed in a long time to that day. When I kept on rubbing his back, that's when the police came and said, "You're a witness." I said, "No, I hit him." And that's what happened. I'll just tell you what happened at the scene. But as far as that, I bought me a bottle of brandy, went to the casino, small bottle, which I do all the time when I go to the casino. I poured it in there, I walked in there with my beer and my liquor, and I drank it. I bought a couple more things of beer, and bartenders know me, they know I was slurring my words. I was intoxicated. When I felt I was a little over-intoxicated, I went home. First of all, I should have never went home because my fiance, I should have never left. My fiance was at home. I could have just called her. I thought I could make it home. And since this incident, I ain't tell you anything, like I lost my fiance. I got kicked out. I lost my apartment. I was at Sway's for like 7 years. I lost my job. Since I've been home for 20-something years, my son was 7. He's like 32 now. I've never been in no trouble. I got 5 grandkids. The 2 oldest ones is mad at me. My daughters is mad at me because they feel that everything I try to teach them and my grandkids, there's no way I would never do this. And there's no way I would never thought I'd do this. I've been thinking about this since May 12th, ever since this happened. And I would never ask you for the forgiveness, because if it was me, I won't forgive me either. And that's all I say, Your Honor.
Thank you. Anything else on behalf of the state?
No, Your Honor, thank you.
Well, this is a crime that's completely 100% avoidable. And it's alarming to hear that this is what you do all the time, that you grab your bottle and your beers and head down and drink and drive. And this is 100% totally avoidable. And the court respectfully disagrees that you could not contemplate the harm that was caused. How can you contemplate what could happen? Certainly anything can happen when you get behind a 2-ton vehicle and drive intoxicated. The evidence is clear about just how significant the harm was. And it's heartbreaking too, to see Mr. Cole approach in a wheelchair that he may be in for the rest of his life. And although he feels that he has lost so much, quite clearly he still has the love of his family and a voice that is strong. And the sadness that accompanies the pain that he has suffered physically, emotionally, psychologically, with pain every day, with what he feels is disfigurement, not being able to enjoy the pleasure of serving a community where he served for 23 years, was all taken because of a thoughtless act that you apparently do over and over, and that we all know about and can be avoided by being responsible. And I appreciate the fact that you expressed in this letter to the court that you feel terrible about this, that you wish you could take it back. Well, you could have prevented it. And that's the part about these offenses that is just so maddening and so very sad. In imposing felony sentences, the court's required to consider the purposes of felony sentencing, which is to protect the public from future crime by you, to punish, that's the punitive aspect, and to use resources as efficiently as we can. In achieving those goals, the court's required to consider if you're likely or unlikely to reoffend, and that's called recidivism, and there's basically a checklist that the court considers. 292912 of the revised code indicates factors that would show that you're likely to reoffend and factors that would show that you're not likely to reoffend. You do have a criminal history, and yes, it is remote in time, but I believe you have about 5 prior felony convictions. All but one were for drug trafficking or drug possession. So you don't have any alcohol-related offenses, but you certainly have offenses in your past that involve the use of illegal narcotics. When it comes to considering if you're likely or unlikely to reoffend, a criminal history would indicate that you are likely. The remoteness in time weighs in your favor. You issued an apology today. I'll give it the weight that it deserves. With respect to the seriousness factors, they are as high as they could possibly be. This was something that was completely 100% your doing. The victim in this case is fault-free. He has suffered. I know you're suffering too because your relationship has ended and you've got people in your life who are upset with you. Well, that's understandable. Here we have someone whose life, as he knew it, in every which way has changed, with the exception of the obvious love that your family has for you and the support that you have from a community who has also suffered by this crime. This is a person who's a public servant and is felt in the community where he served. This is about as tragic as it gets without the taking of a life. So when it comes to considering those seriousness factors, I do find, consistent with the state's argument, that they are greater than the factors that typically constitute an offense of this nature. Hearing you say that this is what you do all the time, which is also evidenced by there being an empty bottle of booze in the car and a beer bottle or beer can under the seat, consistent with what you said, that just goes to show that this is very serious and that there has been a disregard to taking to the roadways in a responsible fashion because just this kind of outcome may occur. I do believe that prison is consistent with the actions that brought you before this court, having considered the purposes and principles of felony sentencing. I wish there was a sentence that could be imposed that could change what happened here. But if nothing else, perhaps this will be a cautionary tale to others about how havoc can be wreaked on so many lives, and the fallout on an entire family and community is great indeed. With respect to the felony of the 4th degree, I'm imposing a term of incarceration of 18 months. With respect to the misdemeanor DUI, which gave rise to this whole thing, which is not the first time we've done it. Maybe you weren't convicted of it before, but by your own words, this is what you do all the time. I'm imposing 6 months, and pursuant to 292914C of the Ohio Revised Code, I am imposing consecutive terms for an aggregate of 2 years, finding that the consecutive sentence is necessary to punish you based on the gravity of what happened to Mr. Cole. Consecutive sentences are not disproportionate to the seriousness of your conduct. They are not disproportionate to the danger that you pose to the public, especially making it just a course of habit to drive and to drive drunk. Also, at least 2 of the multiple offenses here, the 2 offenses, were committed as part of 1 or more courses of conduct, and the harm caused was so great or unusual that no single prison term for any of the single offenses would adequately reflect the seriousness of your conduct. You will receive credit for any time that you've served. It's a sad day indeed. I wish the best to everyone who is involved here, yourself included. I hope that this is a time for reflection and change, and regarding others on the roadway in a way that's very serious. Although I'm suspending your Ohio driver's license for a period of 10 years, I'm imposing court costs. Community work service may satisfy the cost of this prosecution, and I'm imposing a fine of $1,075. The restitution has previously been ordered. My heart goes out to every person impacted by this offense. I'm so sorry for what's going on here. You are still who you are, sir, and you have something to contribute to all of us. Just coming in here today, I believe that you continue to serve your community. My heart goes out to you and your family. Is there anything further on behalf of the state?
No, thank you, Your Honor.
Mr. Roby?
We would just preserve an objection to the consecutive sentences. Thank you.
Okay, your objection is noted, and I indicated the basis for that. Sir, best wishes to you. You are remanded, and we are in recess.
Here's what this.